Thank you very much indeed, Madam Chair. It's a pleasure to serve under your chairship again today. So here we go again. Day 2 of committee stage of the third asylum bill in less than 2 years, and day 643 perhaps of the Rwanda psychodrama that the Conservative Party continues to inflict on our weary and baffled nation. And let's not forget that this whole saga started off as Operation Save Big Dog, Madam Chair. That desperate and thankfully doomed attempt to save the skin of Boris Johnson. But then, for some bizarre reason known only to the benches opposite, it didn't fade away once Mr. Johnson exited stage right. No, quite the opposite took place. Instead, it took a life of its own. It evolved into an article of faith for the Conservative Party, a purity test that has come to define whether or not you're a true believer. And so vast quantities of political capital and untold amounts of government time, resources and energy have been squandered on a policy that at most might possibly one day enable the transfer of a few hundred asylum seekers to Rwanda. It truly is an extraordinary state of affairs, Madam Chair. And meanwhile, out there in the real world, food bills are spiralling, mortgages are going through the roof. There are 7.8 million people on NHS waiting lists. Raw sewage is being pumped into our rivers, and at least 30,000 people risked life and limb to cross the channel on small boats. And nothing in this bill will address any of the challenges that I've just outlined, not even that last one. As I said yesterday, the Rwanda plan is extortionately expensive, with £400 million on its way or committed to the government of Rwanda without a single asylum seeker ever being sent there. And in addition to that vast sum, it will cost at least £169,000 to send each individual asylum seeker to Rwanda, probably far higher than that, but the government is refusing to come clean on that point. It's also unworkable because there is no evidence that sending just a few hundred asylum seekers will deter the tens of thousands who are crossing the channel each year. Desperate people who have risked life and limb crossing continents to escape from violence and persecution are not going to be deterred by a less than 1% chance of being sent to Rwanda. And, of course, we know the scheme, in addition to being unaffordable and unworkable, is unlawful as found by the Supreme Court due to Rwanda not being, as it stands, a safe country. And yet here we are again, being forced to indulge the fantasies, fixations and psychodramas of the benches opposite. I will be quiet.
That's the narrow legal point. Does he think that it was right for a Strasbourg judge to impose an injunction in the night on his own without giving the British government the chance to make their case? Does he think that was right?
Well, what we are seeing is a complete shambolic incompetence in the asylum system, and if cases are not made clearly and are open to legal appeals will come, and in some cases those legal appeals will succeed. On the broader point, the reality is that the United Kingdom is party to a number of international agreements and conventions, and that reality is extremely important to our national interest, and in many cases strengthens our sovereignty and not weakens it. So we on these benches are absolutely clear that politics is about choices, and when you look at the bigger picture in terms of our country's place in the world, it is absolutely clear that our sovereignty and our national interest is strengthened, not weakened, by being party to these international agreements and conventions. But, Madam Chair, I'll just make a little bit of progress and I'll come back. What is also deeply troubling is that every day seems to bring a new example of the tail wagging the dog. Because we now hear the Prime Minister is assembling 150 judges and 1,000 staff to fast-track Rwanda cases through our courts. Sorry, what? Does the Prime Minister know that under his leadership and on his watch, the Crown Court backlog in this country is at a record high of 65,000, victims of serious crime regularly waiting more than 2 years for their day in court so they can seek justice against their perpetrator, Completely and utterly broken system due to 14 years of Tory incompetence and indifference. And yet the Prime Minister clicks his fingers and is glibly apparently able to magic up 150 judges and 1,000 staff. Where on earth have these 150 judges been hiding all this time, Madam Chair? Are they going to be new recruits, or are they currently working? And if the latter, are they going to be told to drop everything and transfer themselves to dealing with asylum cases? I trust that the Minister will be able to answer these questions today, Madam Chair, but I'm not holding my breath. But regardless of the operational issues, just imagine the impact the Prime Minister's glib announcement yesterday would have on you if you were the victim of rape, who has been languishing for years in our broken judicial system. Just imagine the anger and the disgust you would feel at the spectacle of a Conservative Prime Minister sacrificing your fight for justice on the altar of his desperate attempt to cling to power by appeasing his backbenchers. What an utterly shameful and shabby way for the Prime Minister of our country to behave, Madam Chair. And I will give way to the honourable gentleman.
I'm very grateful to the Shadow Minister for giving way, and particularly on the point that he raised about choices and political choices in this. He is valiantly opposing this bill, and he voted against it at second reading, just as I did. But does he recognise that, given that this is the last session of this Parliament, that the Parliament Act cannot be engaged, and there's plenty that will take place in the other place? The only way the Safety of Rwanda bill becomes law is if Labour make the political choice to say that fighting it and frustrating it any longer is not in your interest.
But, I thank the honourable member for his comments, but we have made absolutely clear that this bill is unaffordable, unworkable and unlawful, and we on these benches will never support any piece of legislation that is guilty of those three sins. So it is as clear as crystal to us that we will, with pride, we voted against it at second reading. With pride, we voted against the amendments that would just make it even worse. And with pride, we will be voting against this bill at third reading. I will give way.
I'm very grateful to my honourable friend, and he absolutely makes the right point with regards to the issue around the purpose of this bill. And let's not forget that there is only one purpose of this bill. And would he agree with me that this is one of the most flagrant attempts we've seen at directly flouting international human rights law, and that's the only purpose of the bill before us today?
I thank my honourable friend for that powerful intervention. It is a bit difficult to determine what the true purpose of the bill is these days, because it has become, I think, embroiled in various Tory internal wars and fights in terms of the factions. It's become embroiled in certain people's leadership ambitions, I think. So it's not that easy to discern what the true purpose of the bill is. But one thing we do know is it will not stop the Tory small boats chaos. That is the chaos that has to be stopped. The people smuggler gangs are trading in human misery. They must be stopped. But we need practical, sensible, pragmatic measures rather than the headline-chasing gimmicks that we have seen from this government over the last years and months. But of course, the irony, I will give way in 1 second, the irony of the announcement yesterday about the judges was, by definition, it's an admission of failure, because it is a recognition of the fact that the bill before us today will fail to prevent the legal challenges and appeals that the judges are going to be working on. So the Prime Minister's announcement yesterday was also further evidence of the profoundly troubling way in which this government is prepared to disregard and disrespect our judiciary. And I would urge members on all benches to take careful note of what Sue Carr, the Lady Chief Justice, told Parliament's Justice Committee yesterday, and I quote, "I'm afraid that this headline draws matters of judicial responsibility into the political arena. Matters of deployment of judges, the allocation of work for judges, and the use of courtrooms is exclusively a matter for the judiciary, and more specifically, a matter for myself and the senior president of the tribunals. It's really important that people understand that clear division. There speaks a true democrat, Madam Chair."
Minister for giving way. The Shadow Minister will know that it is our view on this side that this problem cannot be comprehensively tackled without a deterrent. I can't think of any examples around the world where it's been tackled without a deterrent. Right. I know the Shadow Minister has spoken before about safe and legal routes, and I've asked him questions before about whether he thinks the numbers associated with safe and legal routes should be capped or whether they should be uncapped. Has the Shadow Minister had thought about what the cap level would be? What would be the number?
Well, I thank the honourable gentleman for his intervention. It's clear that in order to stop the Tory small boats chaos, we have to smash the criminal smuggler gangs. That will be done through enhanced cooperation with European partners and allies. A crucial part of that is, of course, the Shadow Home Secretary and the Leader of the Opposition visited Europol recently. Hugely important that we get better data sharing, cooperation with European authorities, Europol, Frontex, in order to be able to smash the criminal gangs upstream. As I will go on to say in my remarks, the more you jeopardise cooperation with our European partners and allies by threatening to leave the European conventions, the more difficult you make it to have that European cooperation, and therefore you undermine your own ability to deter the criminal smuggler gangs. If you were looking for a definition of counterproductive legislation and policies, this would be the one that you would go for. I'll give way to the gentleman.
Very good point about cooperation. And he's right. The only way you can tackle this problem is by a suite of measures under an umbrella policy. But an important part of that, as my honourable friend just described, is deterrent. Because the criminal gangs that he described, their brand, their marketing message is you'll get to Britain and never leave. And sadly, that's been too often the case, has it not?
Well, I thank the honourable gentleman, and as I said yesterday, there are pragmatic, sensible things the government has been doing that we support. The Albania deal, for example, fully supported by ourselves on these benches, and the fact that removals to Albania are facilitated by that deal has acted as a deterrent. It's led to a clear decrease in the number of Albanians trying to come over. Why doesn't the government do more of that? Do the pragmatic, sensible stuff, rather than being sucked into endless bun fights about this Rwanda deal, which is unaffordable, unworkable and unlawful. It's a question of priorities, that's what I would point out to the honourable gentleman. When a government has limited time, resources and energy, focus it on the stuff that works rather than on the headline-chasing gimmicks.
The mantra has been clear for many months from the benches opposite, including himself, about the need for safe and legal routes. So can we have some indication of what the level of safe and illegal routes would be to address the problem? And I put it to him, as soon as that cap is reached, the rest will come by boat unless there is a deterrent.
Well, in terms of safe and legal routes, what I would look at is, as a priority, things like the Afghan scheme, which is completely and utterly broken. We've seen ARAP collapsed, we've seen ACRS never really working. Which is the nationality that is always in the top 3 or 4 nationalities crossing the Channel? It's the Afghans. So I think what we need to do is make sure we get the schemes that are currently in place working properly, and then we need to look at international cooperation, working with our European partners and allies, and creating a dynamic whereby the United Kingdom does its bit as part of ensuring that those who are trying to cross the Channel on small boats do not do so. Okay.
Drawing him back to the actual amendments and to the interim measures of the Strasbourg Court, to build on the question from my right honourable friend, am I right in understanding the Labour Party's position is that it does not want to see reform of Rule 39 interim measures? Because I find that very surprising, given that the UK is working in concert with many, perhaps all signatories of the European Convention on Human Rights to do just that, because most of our friends and allies in Europe consider there to be serious rule of law issues arising from the so-called pyjama injunctions, and we want to see them, like them, reformed. Would the Labour Party abandon that piece of work?
Everything that we do when, as I hope, we enter government will be based on the test. Is it affordable, is it workable, and is it legal? The legal piece has to be based on compliance with our international legal obligations. However, if you cherish something, you also have to be prepared to be open to changing it, to improving it. And it is clear that a global conversation is required about the immigration position in which we find ourselves. A European conversation is required, and absolutely, if we, in concert with our international partners and allies, can find ways of improving the system, then of course we on these benches would be looking to do that. It's unfortunately not a deal that we can negotiate from opposition. It's something that we will certainly be looking to prioritise as and when we come into government. If you don't mind, if the honourable gentleman, I'll make a little bit more progress and I'll come back to him.
Order. Just to say, it is convention that if a speaker is to be intervened on, the intervenee, if that's the word, would be there from the beginning of the speech. And I know the right honourable gentleman came in a little later than when Stephen Kinnock started his speech. Stephen Kinnock.
Thank you, Madam Chair. So it's against the backdrop of chaos, confusion and party before country that we consider the amendments that are before us today, Madam Chair. And I'd like to start by commenting on the amendments in the name of the former Immigration Minister, the Right Honourable Member for Newark. Madam Chair, this bill is riddled with shamefully anti-democratic clauses that undermine the rule of law and seek to undermine the conventions and values that we on these benches hold dear. But perhaps the most egregious example of this is the admission on the face of the bill that its provisions may not comply with the United Kingdom's obligations under international law. And indeed, Clause 3 explicitly disapplies international agreements, including the 1951 Refugee Convention and the 1984 Convention Against Torture. The leader of the more moderate Conservative caucus, the One Nation group, described this approach as authoritarian and a betrayal of who we are as a nation. And he was absolutely right on both points. Our liberal democratic nation is founded on the rule of law and on our respect for the judicial function. Our international standing is founded on our commitment to human rights and international law, and our proud history is founded on the delivery of these principles, including indeed Winston Churchill himself actually helping to establish Britain as a founder of the 1951 Convention. I made the point yesterday, I'll make it again, that it's not for politicians to interfere with court judgments, and it's not for the government to respond in a knee-jerk manner to court rulings that it dislikes. That is the behaviour of an autocracy, not of a democracy. How on earth can our country be the international standard bearer for the rule of law in the face of, for example, Putin's barbarism or an increasingly belligerent China, if we are breaking our own international obligations? Indeed, how can we even hold Rwanda to account on its commitments within this new treaty if we're not practicing what we preach? And then there is the real and present danger that this bill represents in terms of the international agreements that Britain is party to, all of which are central to our national interest.
I thank the honourable gentleman for giving way. Those who are worried about social media may also find it useful to use their phones in the chamber to double-check those international obligations, and indeed the original text of the European Court of Human Rights that says explicitly the high undertaking parties agree to abide by the decision of the court in any case to which they are parties. From the start, it was intended that there was a check and court. I listened to the gentleman opposite. I hope he will accord the same respect and courtesy to me. Does the member agree with me that from the start it was envisaged it was an important check and balance to involve the courts in decision-making?
Well, my honourable friend makes a very good point, and I think, as we've also seen in the letter that Nathalie Oiseau has sent to her about the potential risks that there are to the Trade and Cooperation Agreement and a range of other commitments, it is absolutely clear that it is in our national interest to pool our sovereignty with other nations through these conventions in order to strengthen our own national sovereignty, and I agree absolutely with her on that point. But firstly, looking at some of these agreements, the Good Friday Agreement. The European Convention on Human Rights is woven integrally into many different parts of the GFA. The political settlement in Northern Ireland should not be taken for granted. So disapplying the ECHR in British legislation would be playing with fire in that regard, Madam Chair. And of course, the Prime Minister's very own Windsor Framework, which sought to resolve the issues around trade and Northern Ireland post-Brexit, was agreed on the basis of the UK's full commitment to the GFA. I'm sure that the Prime Minister wouldn't want to accidentally set fire to his own carefully crafted negotiations. Then there is the EU-UK Trade and Cooperation Agreement, which includes clauses on important mutual security cooperation, which are reliant on Britain's commitment to the European Convention on Human Rights. Under Articles 1 and 692 of the TCA, UK withdrawal from the ECHR entitles the EU to immediately suspend or terminate the entirety of Section 3 of the TCA. So introducing notwithstanding clauses into this bill would mean that the government would also be dicing with the risk of jeopardising security cooperation with our European partners and allies. And the irony here is that this very security cooperation and data sharing is of pivotal importance when it comes to smashing the criminal gangs that are behind the small boats crossings. So this bill that is designed to stop the potential of, which is designed to potentially deal with the issue of the small boat crossings and the criminal gangs, could potentially undermine the very cooperation which is supposed to be smashing those very gangs. You literally could not make it up, Madam Chair. So I do not believe that legislative belligerence is in the interests or the traditions of the party opposite, and I certainly don't believe it's in the interests or traditions of our own proud nation. And the amendments that have been tabled by the former Immigration Minister, I'm afraid, would simply increase all the risks that I've described, and so we on these benches will be opposing them. Madam Chair, I turn now to the Labour Party's amendments. Again, I stress that we reject this bill in its entirety and that our amendments are designed to limit the damage of this unaffordable, unworkable and unlawful piece of legislation. A major concern of ours is around the way in which the government is handling the entire Rwanda saga from the point of view of transparency, from everything from the costs to the processing capacity of the Rwandan government to ministers trying to hide the fact that criminals will be sent from Rwanda back to the UK, and the fact that the UK may have to take some refugees from Rwanda. Our Amendment 36, New Clause 7 and New Clause 8, are all a part of an attempt to force the government to shed more light on the less clear aspects of the scheme and to introduce more accountability. Amendment 36 would require that the government publish a full impact assessment setting out the costs per person for the removal scheme and the confidential financial memorandum already agreed between the two countries. We believe the cost per person is far higher than the $169,000 already acknowledged by the government, and we want ministers to come clean on that point. New Clause 7 would require the Secretary of State to report to Parliament on a regular basis, as with the Monitoring Committee every 90 days, on the operation of the scheme, including data on the number of people relocated to Rwanda and the costs incurred by the UK government. Similarly, New Clause 9 would require regular reporting on the number of asylum seekers declared inadmissible under the Illegal Migration Act from the point of its entry into force, whenever that may be, and the number of such asylum seekers who were subsequently removed to Rwanda. New Clause 8 would impose further reporting requirements on the government, including on the number of individuals involved in criminal activity who have been transferred from Rwanda to the UK. In the event of any such transfers, the government would be required to table a debatable motion in Parliament so that MPs could consider whether, in light of the transfers, the operation of the treaty should be suspended. It is important that the British public understand just how many foreign criminals the Conservative government would be importing back into our country as part of this Rwanda deal. Further amendments relate to the Monitoring Committee, a central part of the new treaty which both sides are required to set up in order to oversee the operation of the removal scheme and to provide a mechanism for individual asylum seekers to lodge confidential complaints directly with the committee. The Supreme Court raised initial concerns about the capacity of the committee to review complaints in its judgment. Our Amendment 59 would make the establishment of this committee a necessary precondition for the commencement of this Act, and New Clause 5 would place the committee on a statutory footing. The Monitoring Committee would be required to report to Parliament every 90 days, confirming that all the relevant obligations set out in the treaty are being fully complied with. In the event the Monitoring Committee either fails to meet the 90-day requirement or reports to Parliament that Rwanda is not in full compliance with any provision of the treaty, this Act would effectively be suspended from being in force until any issues with timing or compliance have been resolved. Linked to this, new Clause 13 stipulates that the operation of this Act should be suspended at any time when the Monitoring Committee is not in operation. Finally, new Clause 5 states that it is for a Minister of the Crown and that Minister only to decide whether or not to comply with any interim measures issued by the ECHR for the purposes of blocking a person's removal to Rwanda. Amendment 38 stipulates that in making such a decision, the Minister in question must consult with the Attorney General. Madam Chair, the Conservative psychodrama of the past 24 hours only goes to serve the old political adage. If a Prime Minister is incapable of managing his own party, he must be utterly incapable of running the country. And the resignation of not one but two deputy chairs last night, followed by a 60-strong rebellion, illustrated the level of utter incompetence at the heart of his administration. Now, you know what they say, losing one deputy chair could be down to misfortune. Losing two in one night is sheer carelessness. But at least we might get to see a bit more of the two of them on their GB News show, discussing days of yore while spoon-feeding each other with cold baked beans, which was my personal television highlight of 2023, and also explains quite a lot about the amount of hot air emanating from the benches opposite. I certainly hope to see and hear more of them in this election year. But in all seriousness, what on earth is going on? The country is looking on baffled that the Prime Minister can pay the Rwandan government £400 million for nothing, yet places such focus on strengthening our security cooperation with Europe to stop the boats in the first place, and has spent so very little time in terms of improving our broken public services or helping our struggling households during a cost of living crisis. They're perplexed that the Conservatives spend so many hours on a piece of legislation that isn't really even supposed to stop the boats. It's about the Prime Minister getting a single plane in the air with a handful of asylum seekers on it so he can say, look, I did it. I delivered the Rwanda plan and removed a few refugees. He thinks that the British people will deliver something to him on that basis. We are perplexed because this is not the behaviour and politics we can afford to expect from a British Prime Minister. These are not the serious policies that will fix our asylum system and make our country a better place. All the headline-chasing gimmicks over hard graft and getting a grip. This is not what the British public voted for. Indeed, nobody, not even the public, his own party, voted for him at all. Madam Chair, this plan is a con. This bill is a sham. I urge all members to get behind Labour's amendments in order to limit the damage, and I urge them to vote against the bill at third reading. It is unworkable, unaffordable and unlawful if we are to stop the Tory small boats chaos and end the expensive asylum use of the hotels which are costing £8 million a day. Then this Conservative psychodrama needs to end. We need Labour's 5-point plan to end this chaos, starting with going after the criminal gangs upstream in a new security partnership with Europol. We need a government that puts country before party, and we need a general election this spring.